I think you'll be able to take it, Your Honor. This case was tried over 2 days in November of 2021. The parties had married in October of 2015. They had a child born in January of 2017. The complaint for divorce was filed in November of 2019. And my client, the wife, Ms. Smith, moved from the home in February of 2020. This case is one of the cases that really was at the mercy of a number of circumstances outside of the parties' control, one of which was COVID. The other was the fact that Chancellor Evans retired during the pendency of this case, and so therefore the court was vacant until Chancellor Perry's appointment. Basically, to put it in a nutshell, my client is appealing all of the rulings of the trial court with the exception of the trial court's finding that the child should continue to be enrolled at St. George's Episcopal School. I'd like to start by talking about the problems with the classification of assets. First of all, there are some 16 accounts, bank accounts and small money market accounts that inexplicably, while the parties both treated as marital in their pretrial submissions, and the proof put on by the parties was that these accounts were marital and that they contained income, among other things, earned by the parties during the marriage, the court classified all 16 accounts as separate property and did not include them in the division of the marital estate. So our first issue for appeal is that those 16 accounts, the cumulative total of which is about $40,000, so not an insignificant amount of money, should have been included in the marital estate and divided equitably between the parties. There are an additional 2 accounts. That's the husband's PNC account ending 4406 and his Regions account ending 9445, that throughout the pendency of the case, the husband reflected in his discovery responses were marital. He never claimed that they were separate in any way until approximately a month before the trial. At that point, discovery was closed, the case was already set for trial, and for the first time in a pre-trial filing, I believe his affidavit of expenses and income, his Rule 14C affidavit, reflected that he claimed that those were separate property, one of which, the PNC account, it's clear from the record and from husband's responses to discovery, was established during the marriage, and there was no proof before the court which would support a finding that either of these parties was separate property, other than husband just saying that they were. So it's our position that the court erred in also considering those 2 accounts as separate property. The court did something which I'm just going to candidly describe as weird in how it treated the division of property in this case. There's basically an attempt to reconcile Batson, which stands for the proposition that a short-term marriage, in a short-term marriage, the goal is to put the parties back in the economic position they were prior to the marriage. And then on the other hand, with respect to other assets, the court said, well, wait, no, that's not quite fair either. So I'm going to apply more of the logic of the Bates decision. And so what this resulted in is that with respect to the marital portion of the retirement accounts of both parties, which were substantial, the court gave 100% of the marital portion of each party's retirement to that party. So in effect, it was sort of treated as separate. Then with respect to the house, the court said, well, in order to sort of offset that, what I'm going to do with the house is I'm going to look at the party's income, and then I'm going to inversely give a percentage of the equity to the other party. So for example, since husband made more money than the wife, I'm going to give wife husband's pro rata share of the income of the equity of the house. So essentially, what has resulted in this particular situation is that the wife has received at least of the assets that the court has considered marital, which again, we contend did not include all of the marital assets, a 37% division versus husband's approximately 63% division, which we contend is inequitable, especially given the fact that in this particular case, we contend what the driving factor that should have been in the forefront of the court's analysis of the division of property in this case should have been factor 5 under 36-4-121, and instead, the court, again, looked at the short duration of the marriage, their relative ability for future acquisition of assets and income, the estate of each party at the time of the marriage, although with the exception of the premarital value of both clients or both parties' retirement accounts, there was no proof in the record about the estate of each party at the time of the marriage, other than each party owned some rental property. There was no value established for any of that premarital property. There was no proof before the court with respect to the relative economic positions of the parties at the time of the marriage. Unless the court has any questions about the issue of the division of the property, what is important in this case is that these parties operated, albeit they were married approximately 4 years at the time that the complaint for divorce was filed, they operated as a unit. And they didn't just have appreciation in premarital retirement during the marriage, they purchased a house. They both contributed as wage earners. They had not equal, but relatively comparable incomes. They each contributed to household expenses. They had a division of marital bills and expenses that each of them paid during the marriage. And they operated as a unit to acquire and to build and to preserve a marital estate, unlike the parties in Batson. I want to turn now, since I have limited time, to the issue of the parenting plan that the court adopted. The parties have one child. The husband has previously been married and he has 2 children from his prior marriage. When the court evaluated the factors, the best interest factors in fashioning a parenting plan, and before I get to that, let me back up. By the time of trial, the parties had been operating under a consent temporary parenting schedule for approximately 18 months. And again, this was a consent schedule that they'd been operating under. So what occurred is when the court went through the best interest factors, even though the court found that the majority of the factors or a greater number of the factors favored the mother, the court found that the parenting schedule should be modified to an equal parenting schedule because not implementing an equal parenting schedule essentially would violate the father's parental rights. And if you look at the specific findings of the court, and then you compare the proof in the record, you will see that there was absolutely no proof before the court that an equal parenting schedule had anything to do with the best interests of this child. What Mr. Smith's position was and what the court referred to, particularly in its evaluations of factors 7 and 9 under the statute, is that because it works for his other 2 kids, it must work for this child also. In fact, the proof in the record is directly contrary to that. The proof in the record was that the child was thriving under the current schedule. The mother testified at length, and her testimony is cited in my brief concerning why specifically this schedule worked best for the child. The father's testimony was, well, kids are adaptable. If it works for my other kids, it's going to work for this child as well. So the court's findings, and even in the factors that the court, we suggest, improperly found favored the father, that was the driving force in the court's decision. And this court and the other courts of appeal in this state have repeatedly held that although the statute requires maximizing each parent's time, that has to be consistent with the particular child's best interest. And this court, what this court did, is adopted a schedule for the child of the parties based upon a schedule that worked for children over which the court had no jurisdiction. Additionally, there are some criminal contempt. There were allegations of 7 instances of Mr. Smith's violation of a consent order requiring specific information about itineraries for travel. It is detailed in my brief. The fact that Mr. Smith admitted to 5 of the violations. He admitted that he knew what he was supposed to do and didn't do it. But the court found it was insufficient, even though it was clear beyond a reasonable doubt that he had done these things. He needed something more to determine that he was guilty of criminal contempt. And if the court will look at the decision, which I believe I've cited in my brief, the Duke decision, the testimony which I've outlined in my brief concerning these allegations of criminal contempt and the proof that was solicited from Mr. Smith, the court will see. But not only does it meet the same level of conduct that occurred in the Duke case, it exceeds it. Mr. Smith was...
Can you appeal a finding of not guilty of criminal contempt?
I'm sorry, I didn't hear your question.
Can you appeal a finding in which the trial court found the defendant not guilty of criminal contempt?
I don't believe that you can, Your Honor.
Isn't that what you're attempting to do?
That's what I'm arguing, yes.
Isn't that a constitutional violation?
Well, perhaps so.
Okay. Thank you.
Sorry.
Good morning. May it please the court, my name is Anthony Smith.
But before you get started,
Yes.
I want to make sure you're not a lawyer, correct?
Correct.
Okay. You have any questions about the procedure here before you get started?
I do not.
Okay. You understand, once we start the time, you'll have 15 minutes to tell us anything you want about this.
Yes.
Any questions for us?
No questions?
All right, sir. Just want to make sure we're all on the same page.
All right, thank you for that.
Yes, sir. You may proceed.
Thank you. Well, I wanted to start with the division of marital assets. So first, as we've heard, on the date of marriage, October 24th, 2015, mother was 35 years old and I was 36 years old. As we've heard, this is a marriage of short duration. We were married for approximately 6 years and 6 months. However, we had only been married for 4 years and 22 days at the time of the filing of the divorce. The overwhelming majority of marital property in this case is tied to retirement assets and the equity in the marital residence. Mother came into the marriage with approximately $18,910.50 in retirement assets, $18,040.50 in an IRA, and $735 in a 401k. I came into the marriage with approximately $143,670 in retirement assets, which included an IRA, a 401k, and a pension. During the course of this roughly 6-year, 6-month marriage, mother's retirement assets went from almost $19,000 to over $143,000, which is a 759% increase and roughly equaled the value of my retirement assets at the time of marriage. In contrast, my retirement assets increased 338%. At the time of trial, Mother's monthly 401k contributions were $894.92, which was 10.18% of her monthly gross employment income. Keep in mind, to start the marriage, Mother had only had a grand total of $735 in her 401k. Mother's argument is that she should be awarded a greater share of the marital assets. According to Mother's brief, she was awarded 37.36% of the marital assets, which again are mainly retirement assets and the equity in the marital home. In Batson versus Batson, it states that in cases involving a marriage of relatively short duration, it is appropriate to divide the property in a way as nearly as possible that places the parties in the same position they would have been in had the marriage never taken place. By keeping all of my retirement assets, it places me in a position I would have been in if the marriage never took place. This short-term marriage actually puts Mother in a far superior position than if the marriage never taken place for the following reasons. I've already stated what Mother's retirement was before marriage and at the time of trial. And it's also in the record, Mother still owns her premarital residence, and the record reflects she's built equity in that residence by its increased value in paying down the mortgage, and now she also realizes monthly rental income from that. On top of the equity in her premarital home, she is entitled to some percentage of equity in the marital residence, and that equity stands at somewhere near upwards of $156,000. My issue with the division of assets centers around allocation of net equity in the marital residence. So we stipulated that I would keep the marital residence. The trial court stated for purposes of dividing the parties' remaining marital property, the court assigns father an additional 11% of the party's total gross income based on husband's 2020 capital gains in stock trades and reduces mother's percentage accordingly. The court therefore holds that father receives 69% of the party's total gross income and mother 31%. The trial court went on to state the remaining property should be divided pro rata and inversely based on the parties' respective incomes to account for the fact that father earns more than mother, which came out to the 69% for mother, 31% for father. I go into much more detail in my brief, but pro rata income distribution using the method by the trial court and factoring in capital gains would actually be 62% of income for myself and 38% for mother. There was a mathematical error, which I'll talk about in the brief. However, by giving mother 69% of the equity instead of, for say, 50% of the equity, that amounts to an extra $29,640 in tax-free money for the mother versus the $27,150 in pre-tax capital gains that was factored into the gross income calculation. And the reason for the unequal division in equity in the first place was to attempt to balance out the capital gains. Even though the pro rata income calculation has a mathematical error, the trial court also didn't consider the contribution of each party to the acquisition, preservation, and appreciation of marital property that aligns with TCA 36-4-121C5A. So in my brief, I cited two cases. One was the Amos versus Amos, where the husband made 60% of the income, but was still awarded 50% of the equity in the marital residence. This court based the 50-50 equity award in the marital residence based on the parties' contributions being equal, and husband was also allowed to keep its separate property. In Lewis versus Francis, the husband brought much less into the marriage and contributed much less to the marriage than the mother. This court noted, nothing in the record demonstrates that husband made a contribution to the marriage close to the amount awarded him in the division of marital property. This court also went on to say, husband brought much less than mother into this marriage of short duration and contributed much less to the marriage than mother. To grant him the windfall he seeks would be inequitable. In that case, the trials court decision was reversed, which was an award of $250,000 to the father. As it relates to this case, 34% of the marriage, approximately 2 years and 2 months, we spent separated, living in different residences, going through the divorce proceedings. So for over 1/3 of the marriage, mother didn't live or contribute anything towards the marital residence. As stated in both briefs, the mortgage payments were initially paid based on our pro rata incomes up until sometime in 2018, when mother stopped paying anything towards the mortgage. So when it came to the upkeep, preservation, and maintenance of the marital property, and our contributions were not equal. And mother didn't contribute anything for 1/3 of the marriage, and during the other 2/3, I contributed significantly more. Now I want to move on to the issue of the private school. So the Tennessee Child Support Guidelines classifies private school as an extraordinary expense. The guidelines go on to state, if the court finds private school appropriate, then the trial court is required to calculate the extraordinary education expenses separately and add them to the base child support award. This wasn't done in this particular case. In Bayer versus Bayer, the trial court provided no written findings or justifications for ordering the father to pay for the children's extraordinary expenses other than the children have always attended private school. This court remanded the issue of private school to the trial court to determine if private schooling for the children is appropriate. In the case before the court today, the only findings of fact that the trial court made were that the minor child would attend St. George's based on the financial abilities of both parents to afford St. George's and its many offerings. The affidavits of myself and mother show that the parties cannot afford private school. I am required to pay 50% of the expenses related to private school, but there was never an analysis done to first calculate the expenses associated with private school and then determine if the parties, particularly myself, could afford to pay for private school. The trial court did not take into account also what my new mortgage amount would be from the process of having to refinance the loan on the marital residence to also pay out the 69% of the equity. And this part is not in the records, but we also know that the sharp increase in mortgage rates has a impact in terms of the amount of money available after paying for a higher mortgage. My affidavit, however, showed a deficit even if my mortgage amount remained what it was at the time of trial. The minor child is currently enrolled in senior kindergarten, and the cost of private school is not a fixed cost. Just to provide some context, from pre-kindergarten to 9th grade, the tuition increases by 46%. There is an 11% increase in the cost of tuition from junior kindergarten to senior kindergarten. That's just a 1-year difference. My tax returns and W-2s do not show historical increases in income that would keep up with the rising cost of tuition. Also, the tuition schedule from 2020, which is in the record, was not the current tuition schedule, and it's contemplated that it will change several times over the course of his enrollment in private school. This does not take into account other school-related fees, aftercare costs, or uniforms that are required. In essence, private school would be an ever-increasing financial burden over the years, and the increases in associated expenses would far outgrow my income. And lastly, in this matter, it's been stated I have 2 other children. They do not attend private school, but they do reside with me 50% of the time. They're all growing boys. They're not cheap to feed, clothe, or provide for. And of course, we know the ongoing inflation costs, which makes the expenses that are listed in my affidavit now lower than they should be. Coming back to the classification of assets, we've heard that Mother argues in her brief that 16 accounts were incorrectly classified as separate property of the parties. I take no issue with that argument. However, I would like to state the following. As we heard, the value of those accounts are approximately $40,000. Mother, however, accounts for 47% of the combined values of the accounts that she kept, and my accounts total 53%. Given the total value of the estate and the amount each person received, which is very close to 50-50, I would consider that issue de minimis. I wanted to take time to go back and mention something that Ms. Berry mentioned. So in her oral argument, she mentioned there being comparable income in terms of the contributions to both parties. So one, as you know, we both had read, there was a pro rata inverse of the income to look at the marital equity, and that showed, again, incorrect calculation, but that 69% of the income was mine, and then 39% was Mother's. So our incomes, while they weren't drastically different, there was a significant difference in income. I have no further argument unless there's questions.
I see none. Thank you, sir. Well, you got 2 minutes.
Just to respond to a few of the arguments made by Mr. Smith, a representation he just made is one of the reasons why this court should apply more of a Batson logic to the division of property in this case is because Ms. Smith didn't contribute to the mortgage after 2018. That's because the parties had an agreement that he would pay 100% of the mortgage and she would pay 100% of the child care. So they had a division of the payment of marital expenses in this home. And she did contribute. She contributed her wages and her full salary to the support of the home based upon the parties' agreement about how they would divide expenses. Our statute is not a dollar for dollar who paid what accounting. The contributions of a homemaker would be equally as valuable as Ms. Smith's, and Ms. Smith's are probably more so because she was actually a wage earner and contributing directly to the payment of these bills. With regard to the private school issue, the court made a litany of findings about why the parties were not only financially able to afford the tuition, but also as to why this particular school choice was the correct school choice for the child, both in terms of continuity, stability, and because the option posed by Mr. Smith did not outweigh the benefit to the child of continuing where he was. I will rely on my brief on the other financial issues related to the tuition, which are discussed at length in there, as well as the issue of the court's assignment to Ms. Smith inexplicably of the January through May work-related child care that had previously been in the worksheet. Thank you.
Thank you, counsel, and Mr. Smith. We appreciate your argument. We will take this matter under advisement and attempt to render an opinion earliest possible time. Thank you. You may be excused.